All right, welcome back. Now we're going to spend our last panel talking about IDD at Intercept 3, competency restoration for people with IDD. So Joe Smith meets with his attorney, perhaps in a jail setting or out of custody setting. Someone can have IDD and be competent or not, and how do you know? So we're going to start with Beth Mitchell. So Ms. Mitchell, meeting for the first time, what are some things you're evaluating as you meet a client for the first time?
Yeah, so more than likely, this isn't the first time because we've already had some of these other hearings previously. But what I want to know at this point is whether or not my client is competent or not. And so I'm looking to see whether Joe has an understanding of the charges and the potential consequences, his capacity to tell me about the facts surrounding the events, and to look at his state of mind to try to see if he how he would exhibit in court, in his courtroom behavior. And so the ways that I would do that is, I would observe his, some of the things that we've heard earlier through this panel, right? Observe his mannerisms, see how concrete his thinking is, see if he's got, if he understands metaphors or if they mean exactly what they say, which will happen oftentimes with people who may have an autism diagnosis, not really understand figures of speech. If they respond too quickly, or do I need to wait for their responses? And then a big thing that you see that happens is oftentimes people with intellectual disabilities don't want people to know that. They don't want people to think what they think it means, which is that they're dumb. And so they just parrot what you say. They'll say yes or no to whatever you're asking, whether they understand it or not. So you want to make sure that they're not just saying yes or no, but give them open-ended questions to see if they really understand what you are asking them. And then, some of the questions that I will also ask to try to determine whether or not they may have had some kind of diagnosis in the past, because although we've talked about what is a CCQ, which is a check with the local authority to see if a person has previously received services from that authority, is that for people with intellectual disabilities, they often don't get through the local authority. So those matches may not actually, even though you're checking, they might not actually show up as a person who has previously received services from the LIDA. So I think some of the questions that I like to ask to really get to know whether or not, that might give me an indication whether or not they might have some kind of intellectual or learning disability is asking, did they go to special classes to help them learn in school? Did they learn at home? Did they finish high school, or how old were they when they did finish high school? Do they have a guardian or somebody else that helps take care of them? And who do they live with, right? Do they live at home still, or do they live in like a group home setting? So those are some of the questions that I would ask to try to really figure out whether or not they have the ability to assist me in their defense.
Great, thank you. Is there anything else you'd like to add, Beth, about, things you might take note of when deciding whether or not you want to request a competency evaluation?
So, I think part of the issue with that is attorneys do have ethical duties that if a person truly does not have capacity to raise that issue. And this is really, I think, really a difficult decision for attorneys, because most of the times, if you are raising competency, what it means for an individual, especially an individual who may have a misdemeanor charge, is that they will spend a significantly larger amount of time in jail or at a state institution than they would if they were just pled for that misdemeanor charge. The way the competency evaluation system works is that you are there for what the maximum amount of your charge would be. So you don't get good time credits, and you don't get 3-for-1 credits that you would get in a prison system or anything like that. It's the maximum sentence. And so plus none of that even really starts for a lot of people until they get out of the jail and over to the inpatient setting, either the Sslc for a person with intellectual disability, or as I'll talk about later, potentially even a state hospital. So I think it's the balancing of those two. And if you really believe that you have somebody, your client has a misdemeanor charge and they may be incompetent, is really to try to work to dismiss the charges, because otherwise they are going to spend an inordinate amount of time in jail waiting for services and decompensating while they wait there.
Thank you. So now I want to move over to Judge Cassiati. Judge, we're going to talk a little bit about getting a competency evaluation ordered if you do decide to go in that direction. So how would Joe get a competency evaluation?
Yeah, so either party can suggest by motion that Joe is incompetent to stand trial, or even the court can suggest on its own motion. That suggestion is going to be based on a representation from any credible source. So that could come from a family member, or maybe that comes from the caseworker if he was already receiving services through the LIDA. Most often it comes from the defense attorney who's had observations and communications with Joe. So like I said, most of the time, the defense attorney is going to be the one to request the competency evaluation. And if after informal inquiry, the court determines that there is some evidence to support a finding of incompetence, then the judge must order that evaluation. Typically, the court is going to choose the psychologist that is going to perform the evaluation. Most often, many of the judges will have like a list of qualified psychologists that they feel do a good job with these kinds of evaluations and they prefer to use. And those evaluations on average will cost between $500 and $600, at least here in Tarrant County, and that comes out of the court's budget.
Great, thank you. Beth, I want to come back over to you. Did Joe, or have you ever had another client want you to keep their competency status from the court, or ever insisted that they are competent despite indications otherwise?
Yes, that does happen. And often what I try to do is I try to talk to the client, right, and explain what the process is and what it means, right? That it doesn't mean that they're stupid, that, competency is not just for people who may have an intellectual disability, but it applies to a lot of different people. And that the process is really complicated. And what the law wants is the law wants to make sure that if you're going to go through this process, that you do understand it and that you can help me so that I can help you in that process. And I really try to explain to the client, what that is and why we're doing this process. In terms of insisting, yes, there are times, but like I said, you do have to weigh the balances of you're supposed to represent your client and you have your ethical duties to ensure that you're not trying somebody who is truly incompetent to stand trial. So you do need to weigh those. But then, as the judge just spoke about, a lot of times it won't even matter if I'm raising it because anybody can raise it and that will trigger an evaluation anyway.
Great. Judge, I want to come back over to you for a minute. And as a judge, you have the authority to dismiss Joe's adult criminal case if you believe he is not competent?
No, the court cannot sua sponte dismiss a case. The state must present the court with a motion to dismiss. And, there's been conversation about low-level offenses and misdemeanor cases, and whether the state decides to file a motion to dismiss based on incompetence to stand trial and low-level offenses, that can depend on various factors. It could depend on someone's criminal history or their propensity for violence. Their current offense or their current charge might not be a violent offense. It could be a low-level offense, but that doesn't mean that they maybe didn't have violent offenses in their past, or they hadn't committed violent offenses in their past, and that's something that the state may be concerned about. So community safety of the person, perhaps, the person is a current danger to themselves. They're highly psychotic, they're off their medications. Another issue that has been mentioned is the revolving door issue. The person gets arrested, their case is dismissed without any treatment or without any connection to services, and then they're back in custody within a few days. So one way that perhaps that could be addressed is if the court or the parties would all collaborate and maybe consider what I would call a release plan, connecting the person with services, having them released into the community, maybe monitored in the community, and if all goes well, the state might then be willing to dismiss the case. And then another reason might be that, perhaps the psychologist did find the person incompetent, but found that they were likely to be restored within the foreseeable future. And so the state or the victim might have an interest in seeing that person regain competency.
Great. So now we'll move into the scenario that the evaluation is ordered. So Beth, once you have received the order to get Joe a competency evaluation, now what do you do?
Well, as the judge said, that the evaluation is usually ordered by the court, and so I'm waiting to receive the evaluation. And what I'm really going to want to know is whether, because there's two processes for a person once they're found incompetent to stand trial. It's whether they're likely to be restored to competency in the foreseeable future, or whether they're not likely to be restored. And so I'm really going to look to those two things because they make a difference with where Joe may go and how long he may go for and what criteria. So I'm going to look for those when the evaluation is ordered. But I'm also, again, if it's misdemeanor charges, I'm really going to talk to everybody because once somebody is found incompetent, you can't just put them out on bond with conditions because they're incompetent. So they can't agree to that. So it can only be done when they're still competent. So you're really, when you've got to that point, and if there is, like the judge said, the possibility of looking for services in the community that might work, you need to do that before the person is actually found incompetent to stand trial.
Thank you. Now I'm going to switch over to you, Dr. Campbell. What type of evaluation would a psychologist give to Joe to determine competency?
Yes, so Joe would have a competency evaluation. And if I were going to do that, I would start out with a thorough records review. I would want to see, mental health records, school records, arrest records if he has it, because I'd want to know, what kind of contact he'd already had with the judicial system. If he's been in any psych hospitals, hospital records. Also, I'd want to know what previous services he had, like special ed in school, if he'd had contact with the local mental health authority, and if he'd been in any placements, like RTCs or hospitals, again, psychiatric hospitals. And then when I saw him, I'd start off with a mental status evaluation. If he didn't have valid and current IQ and adaptive behavior scores, then I would want to administer IQ testing and adaptive behavior testing. If I could, I'd want to interview a parent or a caregiver, somebody that knows him and knows his history, so that I could get information about the onset and the development of his mental illness and or IDD. If he's in a jail setting or if he's been in a RTC or a group home, I'd want observations from staff. And then I would administer the CAST-MR, which is a competency evaluation that is designed specifically for adults with IDD. And it covers information about, court processes, and also it has a way of assessing whether or not they're able to communicate about their charge with the attorney. And then I would follow up with a structured interview that has open-ended questions to see if he can apply that knowledge to his circumstance. Now, if I was evaluating for mental illness and there wasn't a question about him being IDD, the only difference that I would have would be, instead of the CAST-MR, I would give something like the MCAT-CA, which is designed for individual adults that don't have IDD, and possibly a personality assessment like the MMPI. If there was a question about malingering, then I might give something like the SIRS, which is a questionnaire that helps determine if somebody is trying to fake a mental illness, and definitely rely on the observations from the staff.
Great. Does the timing of the testing matter? And if so, could you tell us a little bit about that?
It does, because competency is at the present time. You're looking to see if the person is competent at the present time. So if he's not stable psychiatrically, behaviorally, that's going to make a difference in how the evaluation goes. I've seen evaluations from psychologists who've gone to jails, and the person, is dangerous and psychotic. And so they've had to conduct the interview through the jail cell door, and jail staff are there. So there's no way you could give like an IQ test or an adaptive behavior assessment in that situation.
And once you finish your evaluation of Joe, what do you or the psychologist who administered the testing, what do you do next?
Well, you would complete the report, and in completing the report, you want to look at what the law says about what needs to go into the report. And in Texas, a person is incompetent if he doesn't have sufficient presentability to consult with his attorney or rational as well as factual understanding of the proceedings against him. So there are several factors that you need to look at. First is the rational understanding of charges and potential consequences. You have to ask questions to determine if they understand what they were arrested for. And what the possible consequences are. A lot of times they know, yes, I can go to jail, but they don't understand the length of time they could spend in jail. They don't understand what other consequences they could have, like probation. Also, they have to have the ability to disclose to counsel pertinent facts, events, and states of mind. So you need to look at their communication skills. Are they able to communicate with the attorney? A lot of times they have impaired memory, so it's difficult for them to remember a lot of the facts and details. A lot of times when I see them, it's been months since they had the offense, and they've, they don't remember. They have to have the ability to engage in reasoned choice of legal strategies. So they need to know things like plea bargaining. They need to understand the different types of pleas, understand what it means to plead guilty or not guilty. Also, they have to have an understanding of the adversarial nature of the proceedings. So they need to understand that the prosecuting attorney is trying to prove that they're guilty and put them in jail, basically. So a lot of times individuals who have IDD, they have an immature view of the world. And so they see these people as authority figures, and they feel like they have to go along with what they say. So when I'm asking them questions, a lot of times they'll answer the questions in a way that tells me that they would likely go along with the prosecuting attorney if he was trying to get them to say something. They also have to have the ability to exhibit appropriate courtroom behavior. So that means they may have to sit for hours, and they have to be quiet. They have to be still. If somebody is saying something that upsets them, they can't, just speak out and, or lash out. They also, have to be alert and pay attention. A lot of individuals who are taking psychiatric medications, it makes them drowsy. And so they're not able to sit for long periods of time without, and be awake. I attended a court recently with an individual who was on medications like that, and he fell asleep. He slept through most of the court proceedings. And then they also have to have the ability to testify. And if you think about it, testifying is pretty anxiety-provoking for anybody, let alone somebody that does have IDD and may not be able to really follow what's going on. So I have to look for proof that they would be able to testify. I have to look through their records, see how they've interacted in other situations, and also my observations of them during the assessment. So there are usually some questions that the judge or whoever serves the order have. They want to know, does the person have a mental illness? Does the person have IDD? And if so, to what extent does the mental illness and or the IDD impact competency? So I have to answer that question. Also, does he take psychiatric medications? And are the medications necessary to maintain competency? And if he's not competent, then I have to answer the question, can he be restored? In my opinion. So a good report will answer all of those questions, the referral questions, and I want to give reasons and examples for my opinions. I don't want to just give an opinion. I want to give examples of what I've observed or what I've read in the records. And I want to try to avoid giving too much information that's not relevant to the questions. I think sometimes, you can give much maybe background information about the family or something like that if it doesn't really relate to the questions and the opinions that you're giving. And that can kind of bog the reader down and keep them from being able to see the pertinent information. And I also want to avoid a lot of clinical jargon because, as one of the judges was saying earlier, they've had to learn all this language and acronyms, and that may be difficult. So I try to avoid using clinical jargon. And if I do use it, then I want to give a definition of it so that it doesn't confuse readers who are not, trained in that area. Then once I've completed the report, I will submit it to the court and prepare to testify if needed.
Thank you. So you led us right into the competency hearing component. So Beth, can you explain to us what a competency hearing might look like and how you as an attorney might prepare yourself and your client for the hearing?
Well, so most of the time, everybody agrees once you get the report back from the court, if the expert has indicated the person is incompetent. So rarely are there actual competency hearings because everybody agrees. I think one of the things that you want to look for when you're looking at that report is, again, whether they have determined the person is likely to be restored to competency or is not likely to be restored to competency, because that changes the order. If they're likely to be restored to competency, then what happens is they kind of get this free shot at going over at an inpatient facility to try to restore them to competency. And that time period can be up to 60 days for a misdemeanor or 120 days for a felony. And then they come back, and at that point, you need to determine whether or not they truly meet commitment criteria. So then there's a second type of hearing, even if the person's still incompetent. But so you really want to kind of look at those two things. But if there is actual competency hearing, the standard is a preponderance of the evidence, and there's no appeal on that. So if the court determines the person is or is not incompetent, that there's not an appeal of that decision. And mostly it's really it's the expert who's being examined and cross-examined. And if the expert appointed by the court has determined that my client might be competent and I think otherwise, then I may look at finding another expert to determine whether or not my client is competent or not, so I can put that expert on the stand to discuss why they think the person is incompetent.
Thank you. Judge Casciati, I'm going to come back over to you now. And can you walk us through what happens at the hearing if Joe is found to be competent versus what might happen if he is found to be incompetent? What would happen next in those scenarios?
Sure. So if at the hearing or if it's agreed upon that Joe is found competent, the court will enter a determination of incompetency order. A determination of competency, and the court proceedings would resume. So if Joe's not already on bond, then the court may to do the analysis for 17032 as far as releasing on a bond for a person who's been identified with mental illness or intellectual disability. And then the case would progress through the trial court docketing system. So it would eventually end up in a plea or in a trial. In the meantime, if Joe is released on bond back into the community, or if he was already on bond, he can continue to receive IDD services through the local Intellectual and Developmental Disability Authority. So if at the hearing Joe is found to be incompetent, then the court would then look at what the opinion is of the psychologist as to whether he can be restored within the foreseeable future. So if he's incompetent and likely to be restored within the foreseeable future, the court would enter in a finding of incompetence and order Joe into a program for restoration treatment that is appropriate for his needs and is available to him. So that could be outpatient competency restoration if he happens to be out in the community. It could be jail-based competency restoration if that's available, or it could be residential placement in a state-supported living center, or even the state hospital. There are some state hospitals that have small IDD units for training. If it is the opinion of the psychologist that he is unlikely to be restored within the foreseeable future, then the court is required to skip all of the initial competency restoration provisions in the code and go to the provisions dealing with civil commitment with charges pending or charges dismissed. So if in this case the charge is going to remain pending, then the criminal court would make a determination as to whether Joe meets civil commitment criteria under the Texas Health and Safety Code. And as has been mentioned, there's long waits, and this would be a long-term commitment.
And who typically writes the order for competency restoration?
I think this is handled differently in the various counties. In some counties, like Tarrant County, the court prepares all of the orders, and in part that's for efficiency's sake. But if there's a hearing and the court makes the determination after that hearing, then the court's going to prepare that order as well. But if the finding of incompetency is agreed upon by the parties, then either side, but as I've seen, typically the state would present the court with an agreed order to sign.
And do you have any tips for the group on writing an effective order for competency restoration?
Sure. I would say, number one, make sure there's a clear finding of incompetence to stand trial. The order should be specific as to the type of commitment and the program for which the person is being committed to. You want to make sure that the order references the correct statutes and the statutory commitment periods. As has been mentioned, there's a difference between committing someone in a misdemeanor case and a felony case. The time periods are going to be 60 days versus 120 days. There's also a difference if you're committing someone for initial competency restoration or a extended commitment, that is a civil commitment with charges pending. You want to make sure that the order tracks the language of the statute under which a person is being committed. And also, I typically will include language to accommodate the 2019 legislative change that allows for dangerous review determination prior to somebody being transferred to a facility. So I'll include language that says, that the person's to be committed to a facility that's designated by the Texas Health and Human Services Commission. And we'll also include language in there that allows for transfer of a person, if they happen to go to a state hospital, to a state-supported living center.
Great. Beth, do you have any other tips for writing an effective order for competency restoration?
Yeah, I think for the, as the judge mentioned, for the initial competency piece, I think everything, that she put in there was that she spoke about. I think if you're really looking at this, if the person's not likely to be restored or if they've come back, the judge mentioned there is different criteria. And I think what we see often is when somebody is being committed to an SSLC, that we often still see the commitment orders saying they meet the mental health code criteria. And that is not the criteria for commitment to an SSLC. It is a completely different criteria and a different burden of proof in order to be committed to an SSLC. And so so if somebody is unlikely to be restored and is on, commitment charges pending, then you really need to ensure that standard is the standard that's included in the orders.
Thank you. And you kind of led us into the next discussion and talking about if someone is going to be committed to a state-supported living center. So, Beth, are there different places where Joe could go for restoration? Let's say maybe if he has MI and IDD, one or the other.
Yeah. So if an individual has an intellectual disability and they have, so previously was if you had a violent felony charge, would not matter if you had an intellectual disability or a mental illness, you automatically went to a maximum security facility, and that was either Vernon State Hospital, Rusk, and then now there's another facility, a couple of other facilities that are being built that will have maximum security beds. And you would have to go there. And so even if you had just an intellectual disability, you would still go to a state hospital. And that in the state hospitals, Vernon, for the maximum security facilities, they only have one unit that serves people with intellectual disabilities. So if that was where the individual had to go, their wait time was easily a year previously, and now with COVID could be a year and a half, if not longer, before they could get in. But they also can go, as the judge indicated, to an outpatient competency restoration program or a jail-based competency restoration program. Those are limited. There's only currently 5 jail-based competency restoration programs in the state, and I think there's maybe 20 some odd outpatient competency restoration programs. There may be more now, but there's not one in every community. So, and they would have to also be able to accommodate somebody who does have an intellectual disability in terms of how they are providing the curriculum to restore to competency. And then, of course, there is also the possibility that somebody could go straight to a state supported living center for competency restoration, usually if it's a misdemeanor charge, or as the judge said, they're now, due to legislation that was passed during the last session, HHSC could override a person who might previously had had to go to a maximum security facility and could then directly go to an SSLC. And currently, I think we've talked about this before, there's 2 SSLCs that take people who are incompetent, and that is San Angelo, who takes women, and then Mejia, who takes the men who are found incompetent to stand trial.
Thank you. And Judge, do you have anything else to add regarding the outpatient competency restoration and jail-based competency restoration programs?
As far as what they would look like for Joe, if he's in the community and able to do outpatient competency restoration, then he would continue to live in the community. So that could be living with family, it could be living in a group home, or maybe even on his own if he's able to do that. Within the outpatient competency restoration program, he would be assigned a caseworker, and that caseworker would provide restoration services as well as sort of coordinate any IDD services or any other types of services he may need. Perhaps, if there's substance use services or programs that he may need, that caseworker would be able to coordinate those services and programs for him. As I mentioned, he would receive competency restoration training, and that would take place at least twice a week. Prior to COVID, that included some group sessions, but right now all of those sessions are individual sessions, and are some of it happening by phone or by video. Outpatient would also include service coordination for like housing, if he needs housing assistance, rehabilitation services, any other transitional services that he may need once a case is disposed. And if his case is pending in Tarrant County and it was pre-COVID times, then he'd be meeting with me monthly at our outpatient competency restoration docket for check-ins and just to see how things are going and monitor progress and so forth. With jail-based competency restoration program, if you were still in custody and committed to that program, then hopefully you'd be able to be housed on the mental health pod within our jail. He would receive competency restoration training 3 times a week. That would also, again, prior to COVID, include some group sessions as well. He would receive any sort of psychiatric services if that was necessary. He would have provider appointments, receive medication through the jail. And also there is opportunity for some substance use counseling within the jail as well.
Thank you. And Claire, I want to come over to you really quickly and talk a little bit about, what the impact is on the SSLC system when we have, some of the issues that we face by sending someone with a pending misdemeanor for inpatient, maybe at the SSLC. So can you talk to us about what we could all do to work together to maybe shorten that list?
Absolutely. You're absolutely right. So one of the things that we've talked about that can be an obstacle for folks, especially that have IDD, is that when you are ordering a restoration services, there's, it's Mejia or San Angelo. There's 2 centers, and Texas is a very big state. So obviously, some operational issues, it kind of causes a bottleneck, right? So you really want to make sure the folks that are ordered for restoration services need to come there for that reason. The other issues that we'll sometimes see is if there's any flexibility while folks wait to come to the Sslc for those restoration services. Is there flexibility for them to receive services outside of the Sslc because of that wait? Or do they really, again, it was determined they need to come to us? The bottleneck is just kind of in pros and cons of different options that might be available for that person before they come to us. A couple other things that, from the Sslc perspective that we see with competency orders too is kind of going back to another mention about collecting information and really sharing really great communication with folks. So if someone is going to come to us, typically that restoration order comes from the justice involvement or from the justice side, unlike most of our commitments that come from the LIDA or from a community side. So sometimes we don't have a lot of information about that person. So it's really important to have great communication between the jail or the court and the Sslc for us to collect as much information as we possibly can so that when that person comes to us for restoration services or may continue to stay with us even after that period, that we've got as much information as we can to best prepare our staff and develop a course of treatment for the person, even if they're with us for a few months or not. Another thing, again, from the Sslc perspective, I would say is folks just being mindful about the impact of eligibility when it comes to competency. So some cases, I'm not a legal expert by any means, but sometimes we see folks that will come on a restoration commitment, be determined competent in the way that our Sslc folks determine it, and then it goes back to the court and they don't necessarily agree. So that person stays within the Sslc, but may have been determined competent and may have IQ scores that are, again, now above the threshold of 70. So that starts to kind of get into some restoration issues there. So that's something to be mindful. My last soapbox, I will say, for any orders coming to the Sslc, since I have this great forum, is, again, being promoting person-centered language, person-centered respectful language. We still see a lot of orders, competency orders or not, that still use an MR reference or use the R word instead of intellectual disability. So that's something to be aware of. And again, being mindful of the individuals that we serve. So sometimes there might be some bargaining of, if you go to the Sslc, then we'll drop certain charges, or, kind of what that looks like. Really, make your best guess based on the individual and their circumstances, if a commitment needs to be made, what that type of commitment needs, because you may be putting someone with justice involvement in with other individuals who are more vulnerable. So I think that's just an important thing to note. And if all possible, advocate for a person's rights, especially under a guardianship and any kind of orders we see to a commitment order or a guardianship to an Sslc. There's any rights that a person can retain during that process. We look for those in the orders and we look for the stipulations of the court. So that's just kind of my 2 cents on that.
Thank you. All right, panelists, we have 7 minutes to get Joe through the rest of the process. So I'm going to hurry us along here quickly so we hit all of the topics. So what I'd like to, I think, Beth, you may have had one more comment about the kind of admission list process, and then we're going to move on to restoration, discharge, and back to court really quickly.
Yeah, so I just wanted to let everybody know that currently the wait list to get into a inpatient facility is now at 1,400 people. And since March, since COVID started, that wait list has gone up pretty much about 500 people. And so COVID has really slowed it down. And the list is pretty much almost, is going up, tenfold every day. And so really need to be mindful of finding other ways to serve people, get them back into the community, because otherwise they're also sitting in jails who don't have enough staff to even work with these individuals, again, because of COVID. So we really need to look at ways to find ways to get these people out of jail and get them into community-based services.
Thank you. All right. So Dr. Campbell, can you give us a quick snapshot of what restoration would look like if a person does end up in an SSLC?
Yes. So as they mentioned earlier, he would likely be with us for up to 120 days. And during that time, he would have group and or individual sessions of competency restoration training, where he would be learning the legal processes as they relate to his charge. At the same time, he would also be getting medical treatment, psychiatric treatment, behavioral treatment. So he would be stabilized in all of those areas. Now, our curriculum is based on the Slater method, which covers knowledge-based lessons, teaching them, the terms, what the lawyer does, what the judge does, et cetera, and also how all of that applies to that person's particular case. We use a lot of different teaching modalities because a lot of our individuals have difficulty with reading and writing. So a lot of it is presented orally. And we use, pictures, videos, role plays. We even have a staff who does a rap song where she inserts the terms into the rap song to help them remember. So during that time also, he would have determination of intellectual disability because, as was mentioned earlier, when we get these individuals from the court, they don't go through the LIDA oftentimes, and so they don't come with a DID. And so we will do our own IQ testing and adaptive behavior assessment to determine if they are eligible for services at the Sslc. And then they will have a competency evaluation if they're adults and a fitness if it's a juvenile.
Thank you so much. Now we're going to talk about discharging from the Sslc. So once a person has been through the process, Judge Cassiati, can you explain for the group what a community living discharge plan is and how that might happen when someone is under a forensic commitment? And do you include that information on your order for competency restoration?
Yes. So generally speaking, a community living discharge plan is a written plan of the needs of the individual and then the services that are available in the community that would meet those needs. So these services will generally have been secured for the person prior to the time that they are transitioned from the State Supported Living Center to the community. And it addresses things like housing, employment, income, benefits, any behavioral issues, any triggers for the defendant, what medications they need, and how they're going to obtain them, as well as counseling and programs that are needed, among other things. The plan will also detail the level of supervision the person needs and will get. Additionally, it will lay out a time frame for reaching goals that the person wants to obtain while they are out in the community. So in my experience, once the court receives notice from the State Supported Living Center that in their opinion, the defendant no longer meets criteria for residential placement and is ready to be transitioned into the lesser restrictive environment of the community, a hearing will be set by the court. Prior to that hearing, the community living discharge plan will be provided to the court and to the parties so that it could be discussed at the time of the hearing. And if the court approves placement into the community, then in my experience, what I do is I draft an order with specific orders or specific conditions that are taken directly from that community living discharge plan. So I want to make sure that not only Joe or the defendant, but also the outpatient providers know exactly what the court expects once he is transitioned into the community.
Great, thank you so much. And the judge is correct. There's a lot of coordination that happens between the Sslc, the court, and the LIDA to make sure that transition is successful. And I think that's a key takeaway. So Beth, we're going to move forward and talk about back to court. So let's talk a little bit about, what policies and procedures for attorneys or for courts are there regarding individuals with IDD who return back to their communities?
Well, so just one thing that's different between IDD and MI commitments is that IDD commitments are lifelong commitments. There is no annual review for those commitments. And so, but the state supported living centers do annual reviews to determine if they believe a person is ready to move to the community. And so they do submit that information to the court, and the court by law is required, once they receive that information, to have a hearing if they are not going to allow that person to be discharged. And they are required to have a hearing on that. And then, as the judge said, going through the process that she had talked about in terms of there's a lot of ways to ensure there's continuity of services into the community and a lot of people who are there to help the person move into the community. So that's a really big piece to know. And I think attorneys need to know that I mean, I guess it depends on the court, but often once you've been assigned to a case, I don't think attorneys realize that these cases go on, and they're usually still appointed come the annual evals, right? The annual reviews of this stuff. And so they need to make sure that they are aware that they still do have a role in this process as it goes through. And I see that my time's up, so I will stop.
I think we could all talk for days topics. And I do know that we have had to cut a little bit of our conversation short, but we did get Joe all the way through. So a huge thank you to all of our panelists through this entire afternoon for walking us through the sequential intercept model as it relates to someone with IDD. Obviously, this is a huge topic area to cover. We appreciate you all condensing it down to 3 45-minute panels.